Stop. If you've flown anywhere in the last few years, ICE has a file on you. Your name, every flight you've taken, where you went, how long you stayed. And nobody told you. This isn't a conspiracy theory. This is happening right now. And if you're on a visa, a green card, or waiting for one, this could destroy your case without you even knowing it. In the next 20 minutes, I'm showing you exactly what they're tracking, who's at risk, and the one thing you need to do before your next flight. Don't skip this. Let's start with the facts. The TSA, which is the agency responsible for security screening at airports, has been sharing passenger manifest information with ICE. Now, this might not sound groundbreaking at first, because government agencies do share information for security purposes. But here's what makes this different and concerning. The data being shared includes your full name, date of birth, flight itinerary, travel patterns, and in some cases, information about who purchased your ticket. This goes beyond basic security screening. We're talking about building detailed travel profiles that ICE can use for immigration enforcement purposes. This practice has actually been happening for years, but it's only recently come to light through Freedom of Information Act requests and investigative reporting. The concerning part is that many travelers had no idea this was occurring. There was no clear notification, no consent process, and limited transparency about how this information would be used. Here's how it works in practice. When you book a flight, the airline creates what's called a passenger name record. This record contains extensive information about your travel. The TSA receives this information for security screening purposes. Then, through various data sharing agreements and protocols, this information flows to ICE and other immigration enforcement agencies. Now, you might be thinking this only affects people who are in the country illegally or who have committed crimes. That's not accurate. This data collection is blanket surveillance. It affects everyone who flies, regardless of their legal status. If you're a green card holder traveling to visit family abroad, your information is being shared. If you're an international student flying home for the holidays, your travel patterns are being tracked. If you're on an H-1B work visa taking a business trip, ICE has access to that information. The legal justification for this comes from post-9/11 security measures and agreements between different agencies within the Department of Homeland Security. Both TSA and ICE fall under this umbrella, which makes data sharing between them easier from a bureaucratic standpoint. However, the scope and scale of this sharing have expanded far beyond what many legal experts believe was originally intended. What makes this particularly problematic is the lack of oversight. There's limited transparency about how ICE uses this information, what triggers further investigation, and what safeguards exist to prevent abuse. We've seen cases where people have been flagged simply for traveling to certain countries or for traveling frequently, even when their visas and status are completely valid. Let's talk about who this impacts, because understanding your risk level is crucial for making informed decisions. While this data sharing affects all air travelers in theory, certain groups face significantly higher risks. First, let's talk about visa holders. If you're in the United States on any type of temporary visa, your travel patterns are now part of your immigration file, whether you realize it or not. This includes H-1B workers in specialty occupations, L-1 intracompany transferees, O-1 visa holders with extraordinary abilities, and treaty traders and investors on e-visas. For H-1B holders specifically, frequent international travel can sometimes raise questions about whether you're actually working in the United States, as your visa requires. I've seen cases where people were pulled aside for secondary inspection simply because they traveled abroad multiple times in a year, even though their travel was completely legitimate and approved by their employers. Students on F-1 and J-1 visas face unique challenges. Your student visa requires you to maintain continuous enrollment and make normal academic progress. If you're traveling during the semester when you should be attending classes, that could trigger questions. Additionally, if you're on optional practical training after graduation, frequent travel might raise concerns about whether you're actually working in your field as required. Green card holders might think they're safe, but that's not entirely true. If you're a lawful permanent resident, extended trips abroad can raise questions about whether you've abandoned your residency. ICE now has detailed records of exactly how long you've been outside the United States. If you're traveling for 4, 5, or 6 months at a time, that information is documented and could be used against you in future immigration proceedings or citizenship application. People in the middle of adjustment of status applications are particularly vulnerable. If you've applied for a green card and you're waiting for approval, any international travel should be carefully considered. With ICE now having access to your complete travel history, unexpected trips or frequent departures could complicate your case. Then there are people with pending asylum applications, those on temporary protected status, and individuals with DACA. For these groups, any interaction with immigration authorities carries additional risk, and having your travel patterns monitored adds another layer of concern. Even U.S. citizens aren't entirely unaffected. If you're traveling with family members who have temporary status, if you're sponsoring someone for immigration benefits, or if you're married to someone going through the green card process, this data collection could indirectly impact you. What's particularly concerning is how this information can be used retroactively. Let's say you traveled internationally 2 years ago and everything was fine. Now you're applying for a green card or citizenship. That old travel data is still in the system and can be reviewed as part of your application. Immigration officers can see patterns over years, not just recent trips. The risk isn't uniform across all visa categories either. Certain countries of origin face more scrutiny. Travel to certain regions can trigger additional flags. The algorithms and systems that ICE uses to analyze this data aren't public, which means you don't really know what might cause you to be flagged for additional screening or investigation. Now let's get into what this actually means for your day-to-day life and your immigration journey. Understanding the implications helps you make better decisions and avoid unnecessary complications. First, secondary inspection at airports has become more common and more intensive. Secondary inspection is when you're pulled aside after going through passport control for additional questioning. With ICE having access to detailed travel data, officers can see your entire travel history instantly. They know where you've been, how often you've traveled, and how long you stayed abroad. I want to share a real scenario that illustrates this. Imagine you're an H-1B worker who travels to India every year to visit family. You typically stay for 3 weeks. This year, due to a family emergency, you stayed for 6 weeks. When you return, the immigration officer at the airport can see that this trip was twice as long as your usual pattern. They might pull you aside to ask why. They might question whether you're still working for your employer. They might even ask to see proof of your continued employment. Is this legal? Yes. Is it fair? That's debatable. But it's the reality you're facing. For students, the implications can be even more complex. Your F-1 visa requires you to maintain full-time enrollment. If you travel during the semester, immigration officers can cross-reference your travel dates with the academic calendar. If you left the country when you should have been in classes, you'll need to explain why. Maybe you had permission from your designated school official. Maybe it was spring break. But you need to be prepared to provide that explanation. Let's talk about the impact on green card applications. When you apply for adjustment of status, USCIS reviews your entire immigration history. They look at whether you maintained lawful status, whether you followed all the rules of your visa category, and whether you were physically present in the United States as required. With ICE data now integrated into this review process, any gaps or inconsistencies in your travel history will be flagged. Here's a specific example. Let's say you were on an F-1 visa and you took a semester off to travel in Europe. You thought it was fine because you planned to re-enroll the next semester. But technically, Your student status terminated when you stopped being a full-time student. That trip to Europe is now documented in the ICE database. When you later apply for a green card, USCIS will see that period and question whether you were out of status. This could delay your application or even lead to a denial if not properly explained. For people applying for citizenship, the physical presence requirement becomes easier to verify, but also easier to challenge. You need to be physically present in the United States for at least 30 months out of the 5 years before applying for citizenship. Immigration officers can now pull up exact travel dates rather than relying solely on what you report. If there's any discrepancy between what you listed on your application and what's in the database, you'll be questioned about it. Renewal applications for visas are another area where this matters. When you renew your H-1B, L-1, or other work visa, the immigration officer reviewing your case can see your complete travel history. If you've been outside the United States for extended periods, they might question whether you're actually working in the job that sponsors your visa. There's also the issue of inadvertent violations becoming permanent records. Maybe you traveled on a visa that didn't allow for that specific type of trip. Maybe you made an honest mistake about the dates you were allowed to stay abroad. These errors, which might have gone unnoticed before, are now documented and can come back to haunt you years later. Business travelers on B-1 visas or visa waiver program visitors face scrutiny too. If you're coming to the United States frequently for business, immigration officers can see the pattern. They might start questioning whether you're actually working in the United States, which isn't allowed on a tourist or business visitor visa. I've seen cases where people were denied entry because their travel pattern suggested they were living in the U.S. rather than just visiting. There are several aspects of this data sharing program that haven't been clearly communicated to the public, and you deserve to know about them. First, the retention period for this data is much longer than most people realize. This information isn't deleted after your trip is over. It's stored in databases that can be accessed for years. Some reports suggest that this data is retained indefinitely, becoming a permanent part of your immigration file. Second, the data isn't just sitting in a file somewhere. It's being analyzed using algorithms and automated systems. ICE uses predictive analytics and risk assessment tools that flag certain travel patterns as potentially problematic. You might be flagged not because you did anything wrong, but because your travel pattern matches a profile that the algorithm considers high risk. The criteria for these flags aren't public. We don't know exactly what triggers additional scrutiny. Is it traveling to certain countries? Is it the frequency of travel? Is it the length of your trips? Is it who you're traveling with? The lack of transparency means you can't really know if you're at risk until you're already being questioned. Third, this information is shared beyond just TSA and ICE. Through various data sharing agreements, your travel information can end up with Customs and Border Protection, USCIS, and even other federal agencies. Each agency might use this information differently, and each has its own enforcement priority. Fourth, there's limited recourse if the information is wrong. Database errors happen. Names get confused. Travel dates might be incorrect. But correcting these errors in government databases is notoriously difficult. If you're flagged based on incorrect information, proving that the data is wrong and getting it corrected can be a lengthy and frustrating process. Another point that isn't widely discussed is how this affects family-based immigration cases. If you're sponsoring a family member for a green card, immigration officers can look at your travel history to verify your claims about your relationship. If you claimed you've been living together, but the travel data shows you've been in different countries, that inconsistency will raise red flags. The impact on future immigration benefits is also not clearly communicated. Every interaction with immigration authorities, every secondary inspection, every piece of data collected becomes part of your record. Even if nothing negative happens during a particular trip, the fact that you were pulled aside for questioning is noted. Over time, These interactions build a profile that can influence future decisions about your applications. There's also the issue of parallel construction. This is a law enforcement technique where agencies use one source of information to discover something, then build their case using different, more legally defensible sources. Your travel data might prompt an investigation, but the government might use other evidence to take action against you. This makes it very difficult to challenge the use of your travel information because it's not the official basis for the action. Given everything we've discussed, let's talk about concrete steps you can take to protect yourself and minimize your risk. These aren't guarantees, but they significantly improve your position. Step 1 is documentation. Before you travel internationally, document everything. Get written approval from your employer if you're on a work visa. Get a letter from your designated school official if you're a student. Keep copies of your itinerary, your reason for travel, and any supporting documents. If you're questioned when you return, you'll have everything you need to provide clear answers. For students specifically, make sure your travel dates don't overlap with important academic dates unless you have explicit permission. Keep your I-20 travel signature up to date. Many students forget that their I-20 needs to be signed for travel within the last year. An expired travel signature can cause serious problems at the border. Work visa holders should maintain clear records of their employment. Keep pay stubs, tax returns, and letters from your employer confirming your continued employment. If you travel for business, keep documentation of the business purpose. If you travel for personal reasons, be prepared to show that you're taking approved vacation time and that your employer expects you back. Step 2 is being strategic about your travel patterns. If you're in the middle of an immigration application, minimize international travel unless absolutely necessary. Every trip creates another data point that could potentially complicate your case. I know this is difficult, especially if you have family abroad, but the risk may not be worth it during critical periods of your immigration journey. If you must travel, keep your trips short and well documented. Avoid last-minute trips that might look suspicious. Avoid traveling to countries that have complicated relationships with the United States unless you have a compelling reason and can clearly document it. Green card holders need to be especially careful about the length of trips abroad. The general rule is to avoid trips longer than 6 months. If you must be abroad for an extended period, consider applying for a re-entry permit before you leave. This shows immigration authorities that you intend to maintain your residence in the United States. Step 3 is preparation for secondary inspection. Know your rights. You have the right to have your questions answered clearly. You have the right to respectful treatment. However, you also have obligations. You must answer questions truthfully. Lying to an immigration officer is a serious offense that can result in visa revocation, denial of admission, or even a ban from the United States. Practice explaining your travel history clearly and concisely. If there are gaps or unusual patterns, have your explanation ready. Don't volunteer information, but answer the questions you're asked honestly and directly. Keep digital and physical copies of important documents accessible when you travel. Have your visa approval notices, employment letters, school enrollment verification, and other relevant documents on your phone or in your carry-on bag. If you're questioned, you can provide these immediately rather than trying to explain verbally. Step 4 is staying informed about policy changes. Immigration policies can change rapidly, especially with different administrations. Follow reliable immigration news sources. Consider consulting with an immigration attorney, especially if you're in a complicated situation or if you're applying for a major benefit like a green card or citizenship. Join communities of people in similar visa situations. Online forums and social media groups can be valuable sources of real-time information about what's happening at different ports of entry and what kinds of questions are being asked. Step 5 is addressing problems immediately. If you had a negative interaction at the airport, if you were denied entry, If you were told your visa is being revoked, don't wait to seek help. Immigration problems typically get worse over time, not better. Consulting with a qualified immigration attorney as soon as possible gives you the best chance of resolving issues. Similarly, if you discover errors in your travel history or in immigration databases, work to correct them immediately. File the appropriate forms, provide supporting documentation, and follow up persistently. The landscape of immigration enforcement and data sharing continues to evolve, and it's important to understand what might change in the near future. There's growing awareness about privacy concerns related to this kind of surveillance. Civil liberties organizations have been challenging various aspects of immigration data collection. While these legal challenges take time to work through the courts, they could eventually result in limitations on what information can be collected and how it can be used. Congress has also shown some interest in providing more oversight of these programs. There have been calls for greater transparency about data sharing agreements between agencies and clearer rules about retention and use of passenger information. Technology is also changing the game. Biometric collection at airports is expanding. Facial recognition, fingerprint scanning, and other technologies are being integrated into immigration processes. This means even more data is being collected about travelers. While this is often presented as making travel more convenient, it also creates more comprehensive databases of information about your movements. Different presidential administrations have different priorities when it comes to immigration enforcement. The level of scrutiny you face when traveling can vary significantly, depending on current enforcement priorities. This is why staying informed about policy changes is so important. International agreements about data sharing are also evolving. The United States has agreements with many countries to share passenger information. As these agreements expand, the scope of data collection could grow. Conversely, privacy regulations in other countries, like the European Union's data protection laws, could put pressure on the U.S. to adopt more stringent privacy protections. For visa applicants and holders, we might see changes in how travel history is evaluated in applications. USCIS has been moving toward more automated processing for certain application types. This could mean more reliance on data like travel records and less discretion for individual officers. It could also mean that minor inconsistencies that might have been overlooked by a human reviewer get flagged by automated systems.